Hello, beautiful people, lovers of good things, lovers of goodwill all over the globe. I bring greetings from a grateful heart. Good morning, good afternoon, and good evening, depending on your time zone. Thank you so dearly for always supporting this platform. I really do appreciate. In case you are hearing our voice for the first time, or you are coming across us for the first time, we still remain your one and only Progress News, giving it to you back to back. Remember, in this platform, we react to all videos, and your opinion is highly needed. So sit back, watch this video, and
across the length and breadth of the country. He is a member of the legal team representing the former leader of the indigenous people of Biafra, proscribed IPOB, Nnamdi Kanu. His name is Barrister Ifeanyi Ejiofor. He's joining us this morning. Good morning to have you.
Thank you so much, my friend. It's a pleasure having you. But before I proceed, I believe it's pertinent for me to correct this impression. My client, Nnamdi Kanu'S, is not the former leader of IPOB. Remain the leader of IPOB, and secondly, the prescription of IPOB is the subject matter before the Court of Appeal. So it cannot be effectively be pronounced here that it's a prescribed organization. Because it's an exercise we are challenging before the Court of Appeal, and it's coming up for hearing the appeal on 10th of October 2022. So I wouldn't want to be for action to be classified as prescribed because it's still being contended in court. So it's subject is the legality otherwise of the exercise of the president at the point was prescribed is being challenged in court of law. So
don't worry, we'll come to that because I have an angle to that I'm going to take up. But in the interim, in official government circles, it is prescribed for now, and I want to stand on that.
But in law, it's not prescribed.
It's been challenged.
It's been challenged and it's not prescribed.
Since it's been challenged, but there is an official pronouncement on that. We take it that on this program that is prescribed for now.
Because you can't give legality to you can't make a foundation to illegality. So if you classify this as prescribed at this point in time, recognized by the station, it means you are giving legitimacy to the illegality of the process to which was exercised. So which I challenge before the court. However, I don't want to dwell much. You can still get to that if you want me to explain more.
Yeah, we'll get to that.
As a lawyer who is also in charge of the case at the Court of Appeal, as now, and I've agreed something exchanged. We'll find responded, and it's there for hearing. So I wouldn't want to be party to where people will be saying that before me, directly before me, that been prescribed. No, we are challenging it because it's possible that what will happen in the likely event that the appeal is allowed.
Fine, if the appeal is allowed, we take it from there. But in the interim, you don't have a counter. It's being challenged, but you don't have either an order that let the status quo remain before.
It's automatic. So it's automatic. It's automatic. The Court of Appeal is very clear about that. It's automatic. Once an appeal is entered in a subject matter or a decision of the lower court, then the status quo should be maintained by parties. It doesn't need to. The court doesn't need to give that order. It's automatic. It goes without saying. Appeal has been entered. We didn't stop at final appeal and transmit that court to the Court of Appeal. We also proceeded to file an appellate brief, serve on the federal government. They responded and we replied. So it has gone beyond appeal being entered. So at this point, parties are expected to maintain status quo antebellum before the next size. So,
all right, until we come back to that, for now, let's go to on Tuesday. I think, yeah.
Sure, Tuesday,
on Tuesday, the Federal High Court refused your plea for bail application for Nnamdi Kanu, and then the argument is that somehow that in the last 4 years you've not entered into any application before the court, and then why do you want them to revoke either the warrant of arrest or to grant him bail?
Okay, I believe this should be a convenient forum for this clarification to be made, and I believe it's privileged because I was kind of disappointed with the reports out there at the end of the proceedings, both from the print media, social media, and also television stations, and you have just mentioned it now. The ruling delivered on Thursday, being 28th day of June 2022, was not on bail application. It wasn't on bail application. So the court didn't dwell on issues of bail on 28th. But they have been reported widely, even by lawyers too, and by media people who were there, my pressmen were there. They were talking about denying him bail. That wasn't the subject matter of the ruling. The ruling actually has to do with an application we filed on the 1st day of April 2019, asking the court to vacate the order revoking the bail of Nnamdi Kanu and also issuing bail warrant against him. That was the application taken at the penultimate date, 18th of May, and ruling delivered on Tuesday. So that was the subject matter. That was the purpose of the ruling. It didn't do anything well on the bail application. However, if the ruling has gone in the affirmative, Nnamdi Kanu would have walked out of the court a free person because he's already on bail before he was abducted in Kenya and extraordinary rendition to Nigeria. So we have the court actually, in the course of delivering ruling application for bail at the penultimate adjourned date, requested that the defense team should also avail him of facts and circumstances that led to the disappearance of Nnamdi Kanu from 2017 till the time he was brought before her court. So actually, this is a matter, an application we filed since April 1st. We didn't file it this year. It wasn't filed 4 years after the incident. No, it was filed on April 4th, 2019, and it was filed because on the 14th of November 2018, this matter came up. That was after the bloody invasion of the premises of Nnamdi Kanu by Nigerian soldiers on 14th of September 2017. We had over 28 innocent and civilians were murdered in their cold blood. And in this desperate attempt to kill the Mazi Nnamdi Kanu, he narrowly escaped by risk by mere out of evidence. So, and the matter continued. And when we went back to court, because actually the matter was slated for hearing on 11th of October, on 4th of October 2017, before that incident. And before the incident, Nnamdi Kanu, our client, had publicly made it known to the world that he's coming to court on the 14th. And he actually asked his followers to be in court with him. However, we have also proceeded to take him on trial conference, before that time. Get the readiness for the trial coming up on 14th of October. So, before the bloody invasion of his premises home in Afaruku on 14th of September 2018. Now, if these people had wanted this father to go on, they were waiting for him to come to court on October 14th. And possibly, there's no law that said you will not arrest him. If in the course of enjoying bail, he committed any offense under the law, you can still arrest him and probably amend the charge. The law allows you to do that if their intention was not to kill him. But they took one to his home on 14th of September and murdered over 28 persons. And he never escaped by whisker. So we came back to court to inform the court. And actually, in the course of time, we then filed a suit against the Chiwami staff, directing him to produce our client his personally vetted premises. Then, so it was the ruling of the court on the 14th of November 2018, right? Because when our client whereabouts could not be determined, the court decided to proceed in his absence for trial, and I objected to that. So when I said the trial cannot go on in his absence, that is important for the solicitor to confirm, to ascertain what happened to my client, because something happened. Something supervening event took place, and the court should not close its ears to that. It's known all over the world that his premises was invaded on 14th of September 2014, and people killed there. It's all over the world, reported by, including by a station, reported all over the world. So the court will not pretend that it is not aware of what actually happened. So, but however, in court, you have to come formally before the court, put your facts together, put your authorities together. Then the court now said, okay, now decided to invite the shorties to come and tell the court where the persons he took on bail, where his whereabouts. The shorties were in court on 11th or 14th of November 2018 to tell the court that, look, my lord, we came to court to take this man on bail. And if there's any reason why this man should be, his house should be invaded or should be arrested, I believe we're in a position to be contacted. You put this man on bail, tell us where he is. Okay, we're looking for him. Security agents can as well reach to them easily. They can as well reach to institutions that have many and others who took him on bail. They didn't do that. They now said the court should also investigate. So on the 14th of November 2018, they were there. The court now directed them to appear in court on 28th of March 2019 to explain to the court the whereabouts of Onyendo Mazi Nnamdi Kanu. Then the court did not allow them to come to court, to not allow them to be in court on that day. Proceeded to make an order, directing them to that they should forfeit their bail bond, and also giving them time within which to do those parts. However, in view of the fact that the action, what they are requesting us to do, unless I don't date has been pronounced upon, they went to court of appeal to challenge the pronouncement of court on the 14th of November 2018. And the record were transmitted, appeal entered. So on March 28, 2019, when the application they filed in court was meant to be heard, they told the court, my lord, in view of your pronouncement on the 14th of November 2018, I will go to court because this application has been overtaken by your pronouncement. So we need to also want to make a pronouncement on it. Then the court said, since the appeal has been entered and the record transmitted, that it will not be tidy for the court to start proceed with the hearing of the application. And the court there and then adjourned the matter sine die. Before then, the court said, Ejiofor, I don't want to hear from you for now. I don't want you to say a word. Let me finish with the shorties. Now, the business of the court on the 28th day of March 2029 is simple. To what? To hear the application filed by the shorties, stating in clear terms and facts the whereabouts of the person you gave us on bail. That was the business of the court on that day. Then the court, immediately the matter was adjourned for adjourn sine die. The court proceeded to issue a bench warrant, and also the court proceeded to revoke his bail warrant and issue bench warrant against our client. There was no opportunity afforded our client to state the facts of where he is, and also to tell the court what happened in his premises. So that was based upon which we filed an application promptly, requesting the court to vacate that order he made on 28th of March 2019, because order was made without affording us opportunity to be heard. So in clear violation of right to fair hearing and sundry matters, and also coupled with the fact that the matter was adjourned for hearing of application, not for trial. It's only when the matter is adjourned for trial, there will be the question to tell the court our client is not in court today because of XYZ reason. And to that effect, we have filed this application. So we filed this application on the 1st day of April, requesting my lord to vacate that order he made without jurisdiction, and also and the order he made without jurisdiction, order revoking his bail and order issuing bench warrant. So that application has been pending in court since April 1st, 2019. And several the matter was adjourned, we kept on bringing the attention of the court that we have this application before you. We are urging your lordship to hear it. Court says it's not disposed to hear it, has been disposed to hear it until penultimate adjournment, when the matter came up for ruling on application for bail. The court down the course of ruling, because people should also understand that Nnamdi Kanu has not been technically denied bail by the court. Sure. Because if the court has categorically denied him bail, the court was stated in his ruling of 18th of May. Right? But what court said is that the application for bail filed at this point in time is premature. That it's important for me to also inquire to know what happened to my client, to the person facing trial before my court. Since 2017, he did. I've not seen him until he was brought to court on that until 6th of July, until 7th of July 2021. So, can you people now file application to educate me? Also, tell me what happened to him. That was when we brought the attention of the court. I will have filed this application to April 1st, 2019. That's already got for you. Then it was moved. So the issue of filing the application 4 years after the incident doesn't arise. It should be an oversight on part of my lord. Because let me just classify it as an oversight. Because at the point of taking an application before a court, you must introduce the application you are taking. First of all, you must tell the court this application is dated so and so date. 1, 2, 5, so and so date. Then supported premise on so and so grounds, supported by XYZ number paragraphs of affidavit. Address. So this were the introductory part. Ably stated clearly in unmistaken terms by Leslie Linus, Chief Executive SIN. It was stated in court. So I can't just explain why his lordship stated on view that application was filed 4 years after the incident. So it wasn't filed 4 years after the incident. So before the ruling. So actually, I may not be well much on the propriety otherwise of the ruling because we are challenging the ruling on court appeal. So thank you.
All right. The federal government lawyer has also accused your team of unnecessarily dragging the case by playing to the gallery. What do you have to say about this?
The federal government lawyer saying that
two people ran to the court of appeal. That's the process of.
With respect to him, he's just a new person in the case. He just joined the team, penultimate. He doesn't know anything about the matter. I don't think he was properly briefed because the fact is that it's clear. With respect to him, this one has been on 2015. The federal government has not taken any single step in that case. They've been amending their charge at every adjournment. The last one they amended, but it's 7th time they amended their charge, either reducing or increasing, and the court will keep on striking some of them out. In fact, as a matter of fact, at last adjourned date, the matter came up for it. They amended the charge again. I insisted there must be an end to litigation. There must be it can't continue unabated. It cannot continue that way. We can't continue. This man has committed no offense unto law. You file frivolous and the unfounded charge against him. The charge that cannot even be tried by a magistrate court. It has no ground whatsoever. Then you come back again after 8 counts has been struck out by court, remaining 7. And 7 which you are still challenging the court of appeal to file to also amend the charge. So assuming you want to proceed, actually try this case, conduct this trial, expeditiously as envisaged under the stand rules. What informed the amendment of charge? It's more so that when the charge is untenable in law, how can you tell me that somebody somewhere you never defined the place the person was at the point he was making the broadcast, but the broadcast had in Nigeria without stating the place the information was received and acted upon it, committed an offense? It's not what the law says. It's not what the law says. The criminal law is very clear. He said he must define the place the offense took place. He was committed. It's not what it says. It's mandatory. It's compelling. That has to be done in every charge. The status must be defined of commission of the offense. You must define where the offense was committed. Define every particular of the offense. You bring it in line with the facts you are stating. But in this case, they're lacking. I don't want to go into the merit of the charge because it's a solid matter before the court of appeal. So what I'm saying is that the guy in question appeared in that matter for the first time at the penultimate adjournment.
The federal government has been changing their own legal
yes,
team. Just like you also have changed your own legal team.
We have not been changing.
Michael Zokome didn't start the case.
No, you see, when you talk about changing a team, right, you're talking about a different lawyer taking over the matter. No, we've been on this matter since 2015. Then let's take the Bureau of Law, Michael Zokome, started heading the team, and we're still using the same file. And he hasn't departed. He knew he has the case file. And let me say this to you, Chief Mike Ozekome, right? Chief Mike Ozekome has been working from sidelines in this case since 2015. Has been giving me, so you know about the matter. So he's not a new person in the matter. So, and of course you know him very well. So in their own case, Labaran Shuaibu, who has been actively leading their team, was removed. He was removed. So this young man was introduced at penultimate adjourned day. He doesn't know anything about this matter, even from his presentation before the court. How can you be accusing the defense team of causing the delay? Then are the people, even him, we filed an application for stay. We filed a serve on him since June 7th. We filed a serve since June 7th. Then he only responded on 24th of June. 2 days, a day before the trial. 24th of June was on Friday. So this is the person that's talking about speedy hearing of the case. They are not ready to hear this case. They are not ready to try. What they want to do is they're applying all methods known to them to keep Nnamdi Kanu in perpetual detention. That's what they're doing.
Why do you think so?
I am telling you, I'm in the matter. I'm in the matter. If you see, I've done many cases. I'm not doing only Nnamdi Kanu. I've done many cases when the court of appeal and high courts. So when a counsel is disposed for accelerated hearing of the matter, you will know they have a trajectory, and with this one young man, is also keen to. So you can never accuse us. How can you tell me that the charge has been amended 7 good times since 2015? And in any of the events, I don't be able to establish any of the charge against him. Have no witnesses. Okay, let me just say this to you. The court made an order at penultimate adjourned date, directing that young man to file and serve on us the witness and oath of people or witnesses who are coming to give evidence against our client in court. This is a person who is accusing the first team of being responsible for the claim. The court directed him, made an order that he should file and serve on us the witness statement on oath of the witnesses coming to give evidence on behalf of the federal government. He could not file anything. He didn't file a word. He didn't file any word, any statement, except one person. And they listed about 8 persons who are coming to give evidence about. So I'm saying this as a lawyer, and as a state lawyer for that matter. Yeah, they were only able to find one. This person who said he has about 9 witnesses. And the person who doesn't know the file has nothing to do with the case before the court.
All right, let's move on. There are those who argue or say that the legal team of the Nnamdi Kanu and IPOB have said that the federal government failed to reveal the location of Nnamdi's broadcast, which is allegedly said purportedly led to the violence in the southeast. And some persons are saying that it looks as if this argument and this part the legal team is working is trying to give the matter in Abuja a global dimension or a global jurisdiction beyond Justice Peter Yaku. How do you have to respond to this?
The matter has a global jurisdiction, of course. You know, of course, this matter has resurrected so many legal actions against the federal government in various courts, even including the International Court of Justice, because the act of abduction of Nnamdi Kanu in Kenya, which they have thankfully admitted in one of the final stuff on us last 2 weeks, so that they kidnapped in their own terminology, they said they intercepted him in Kenya. They admitted now they've arrested, they've abducted him and took him to a security facility. From there they brought him to Nigeria. They've admitted they are living on oath. So that has been settled. So, and that has been done in clear violation of several international laws and treaties, which Nigeria is a party to it. So by virtue of which, as I speak to you, we have a case against the federal government in Kenya. We have a case against the federal government before the International Court of Justice. We have a case against the federal government before the Federal Court. We have 2 several cases again, apart from this criminal matter. One is coming up also on 7th of October on hearing. So and also have a case against the federal government before the Court of Appeal. So a lot of actions has been initiated on this arise from this subject matter before the court. So our account of the gross violation of his rights, international rights and obligations.
Do you think you win this case?
There's no case before the court in the first place. I can tell you that authoritatively. What Nnamdi Kanu is facing today is political persecution. Take it to the bank. There's no case against him before the court.
Why do you think it's political persecution?
Let me give you an instance. They have an application, very meritorious application before the court, stating the facts. This application was supported by an affidavit deposed by Nnamdi Kanu when he was instead of Israel, before a notary public, and filed in the court. These facts contain evidence of person who witnessed the invasion of his premises. Direct evidence, not a hearsay. Then it was filed only to get the court to understand that something happened in his premises on 14th of September. Formally, there's no single pronouncement made on that evidence before the court. Now, I don't want to go into that. Before the ruling was delivered on 28th of June 2022, that was on Tuesday last week, the president made extra judicial statement during his interaction with British Prime Minister, where he stated unequivocally that Nnamdi Kanu jumped bail. That's number one. That somebody that will jump bail. This is the area of interest to me. That jump bail. How are you sure that if granted bail, you will not jump bail again? It's conclusive. It's obviously conclusive. This is 5 days before the ruling was delivered. So what are you talking about? There is a serious executive interference in this case. This is the president, with great respect to his office, that started during his state visit to Imo State, when our allies and elders from our region approached him for political solution. He said no, that he wants Nnamdi Kanu to defend himself in law, in court. They want to get involved in the judicial process. Why making pronouncement as serious as what you said to the international community, right, British Prime Minister? And I'm not surprised of what happened on Tuesday. The judge is a human being. We are talking about a country that has no law. Have no respect for rule of law. A country that anything goes. A country that sometime in the past ambushed and they invaded the premises of Supreme Court judges. You know how it ended. So it's not a human being. We shouldn't pity the judge. You see, it's important for us to understand. I issued a statement to that effect. Call on the international community to know what he said and the effect of it on judicial proceeding before the court. And it happened. It happened. Clearly it happened. So there is serious, manifestly evidence to show that executive is interfering in this process.
All right, let's pause here and allow our listeners to share their thoughts, comments, or reactions to what we've been discussing, which is the case involving Nnamdi Kanu. You can join us now on Viewpoint on 0817-8000-947. 0817-8000-947. Alternatively, you can also call 0901-094-7777. Make it straight to the point, and we hope you don't profile anybody. Morning.
Thank you. I thank you, Barrister.
Ifeanyi Ejiofor.
Thank you so much, brother.
Onyemaechi, let's hear you. Kigali, Rwanda.
Yes, Rwanda. I told the leader that he's very good. You see, thank God Nnamdi Kanu happens to be a decision? Has it been Nnamdi Kanu is the American citizen? Do you think that the government will be handling this the way they handle it? And for you to also know, you can Google it. I think it's number 3. I have said it. Those who are justifying the way this case is going, well, they are from a particular part of the country. Why are they not asking this government to investigate those who are controlling this killer henchmen across the country, killing Nigerians, destroying plants and property? They cannot do anything. We've had stories, we've seen people have been shouting on radio. Right? By God's grace, Nnamdi Kanu is still alive, and he will remain alive. God will continue to protect him. We are watching what is going on. But how I wish he's an American citizen. Let me see how Nigeria will be handling this case the way they're handling it.
All right.
Thank you.
Thank you very much. 0817-8000-947 or 0901-094-7777. Hello, good morning.
Yeah, good morning, Mr. Ifeanyi.
Morning.
I'm Chidi. I'm calling from Abuja. In the case of Nnamdi Kanu, I think Buhari is being the judge here and the president. And the
Excuse me, that's Chidi. Chidi, can you hear me, Chidi? When you call, don't just speak without listening. Don't profile anybody. Just make your point without profiling anybody or insulting the sensibility of others, please. I will not take that. Hello, good morning.
Yeah, good morning.
Morning.
My name is Stanley.
Stanley, let's hear you.
Yeah, I want to suggest, from the direct that I was buying. It seems to me from what you explained that Kanu doesn't have anything to speak. So why not evaluate the issue of going through, like talking about the issue of rendition, the federal rendition, granting of bail and all of that? Why not evaluate all of that? Go into the matter, the federal franchise, so that the court can deal with these 7 franchises, discharge and acquittal, or otherwise. Because for me, it seems to me there is delay for both the defense team and the defense to drag the matter for long. Why not so that they forget about whatever the federal government is doing to delay the matter and ask my lordship just to be 8 times to go into this trial properly. And so that once the 7 countries is being checked out, and then he will be free. Thank you.
Thank you very much, Stanley. Hello, good morning. Yeah, good morning. Yeah, morning.
Yes, my name is Gigi. Let me tell you that your president is a lawyer. You should know that it's case of this type of this explain. There's no exchange that can be explained. And each party wants to maximize their own opportunity. Like you say that this one is delayed, it comes in every single case or even the criminality, it comes from. And that's why I'm not happy with this that because this case, you should probably say they can laugh for even saying it. Because the tenant place is nothing else than what we call the Supreme Court. So they should explore for political opportunity to get this case. But the issue of this and all and all the things without this will encourage any government to want to go for political solution. Like the CDS of the best, they said the political solution is even preferred to political solution. And I want to appeal to Kanu camp. They should see how to end it that so that we can see things without me, then they cannot look for political solution. But if not, this case will go to Supreme Court. I know how many years it takes.
All right, thank you very much. Thank you. Hello, good morning. Hello. All right, sorry. Hello, good morning.
Hello, good morning.
Morning. Let's hear
My
you.
name is Lebuga.
Go ahead.
I'm calling from Nger. Now, what I want to say is that look at this case. The truth is that people that have people out there in this country. And that is why they are kind of following this case like this. They are just saying that the young man wants to take their people out there. But the truth is that whatever they are doing, they don't consider that this nation. God must be preserved. That's what I want to say. These people are doing that, that's why they are treating these people like Nnamdi Kanu and all you do. I think they are the worst enemy in the world. They are angry and they will not succeed.
All right.
That's only what I want to say.
Okay, then thank you so much for your contribution this morning. Let's take more calls. Hello, good morning.
Hello?
Yes, good morning. Welcome to the show.
Yes, good morning. This is Emeka Obina calling from Abuja here.
Okay, Emeka Obina, thank you for joining us on the morning drive. What's your take on the issue this morning?
Yes, I remember when Nnamdi Kanu was in Kenya. And one family that has become people to all the whole world for the time. There's not an transgender. I can have
All right, at times, let's just not make this thing look like east-west matter. Hello, good morning. Morning. Let's hear you.
My take on the why is it that the guy Nnamdi Kanu is dragging on? Is it that somebody is saying the truth and you arrest him and keep him in detention? Whereas other headsmen are killing them. Abba, you say they are repentant. And I've never seen anyone in court. This is not a just country. Okay, if Nnamdi Kanu and Ejiofor are pursuing the same case, you release Ejiofor and leave Nnamdi Kanu. Is it fair? I think I'm talking about justice and the APC in Nigeria. A government can see this man that the government is unfair and unjustifiable. I'm not supposed to see
All right. Thank you. Let's give others a chance. Hello, good morning.
Hello, Mr. Victor. Good morning, sir.
Morning, Salasi.
And good afternoon. Good morning to our guests. We want to appreciate you for coming there.
Thank you so much, my brother.
And for the analysis, I want to appreciate you for that.
Thank you so much.
I see this government is like they are one-sided. Sorry to say that. You remember they traveled to Kenya to go and arrest Nnamdi Kanu. While the train victims are nearby Abuja here, they are not even 200 kilometers away from the seat of the government. They can't get the bandits. They can't get the terrorists that are wasting people's lives every day. But they have the resources in order to go to Kenya. You can imagine how much the federal government spends in their force in order to just arrest Nnamdi Kanu. And you see what happened to Ejiofor. So why is it that Nnamdi Kanu on his threat? Even the president rightly said that he won't give him bail. So until maybe another government comes, because the way I'm seeing it, I don't see Nnamdi Kanu being released in this government, because they have already shown it clearly that they are one-sided. If terrorists could get this legacy of doing whatever they will do to Nigeria, and they have done nothing to them, why Nnamdi Kanu? Just injustice to one is an injustice to all. Right. Thank you, I appreciate it.
Thank you, Salasi. Hello, good morning. Hello, good morning. Morning.
Hello.
I'm listening.
Yes, sir. Good morning. My name is OGB, sir.
OGB, let's hear you.
Yes, sir. Good morning, sir.
Good morning, brother. God bless you.
Yes, sir. Uncle Victor, Ejiofor has told you that this is not Peter, and Nnamdi Kanu has put his answer, and that is the truth of the matter. Somebody just asked, what about this one about killing people, destroying homes, and doing, have you heard anyone making to come before? So as far as I'm concerned, this is, the president is looking at 1967 Biafran War, and that is what
OGB. You know how we do it here. If you don't, when you are talking, listening to me, if you are walking out of line and you don't want to listen to me, I will have no option but to give you a red card. Hello, good morning.
Good morning.
Morning, can you speak up a little, please? All right. Hello, good morning.
Good morning, Victor.
Morning, Ali.
Thank you.
Good to have you.
I think on the issue of Nnamdi Kanu, whoever wants to blame the government, he has his own opinion to blame the government. But the government is doing the right thing. So none of us should be looking at our criminality, maybe it's from the southeast, from the north, or the criminality, whoever is a criminal is a criminal. Be it a henchman, be it a kidnapper, be it those who are, terrorizing this country. I think in the country where there's no justice. I think those are people who are touching,
I'm listening.
So those who are touching, so as for me, what of those who have been killed? Me, I am not support of anybody. Either being a kidnapper, a Boko Haram, or whatever, the law should be on to take its course. But we have an army to it. Even today also, the security agencies said they have killed a lot of bandits in Kaduna. They have killed a lot of bandits in Zamfara. And then it is said, is it anybody's business to say they are wrong? And this is a president who has fought, who has made his life for this country. I think what we are lacking in this country is patriotism. Whoever is if you are not patriotic to a country, you will not say anybody who take arms or who want to go on secession, who are those who are kidnapping us, or who are those who are doing banditry on us. Now we'll be taking side. We are not looking from the government side, we are looking from their own side. And we say it's justice, and we want to say it's a sovereign country. I think those who are calling on whoever are against this country are not being patriotic.
All right, thank you. All right, fine, let's return because we have barely 7 minutes to wrap up on the program. You've heard all kinds of submissions. Those who are saying criminality is criminality, irrespective of whether it's secession, whether it's killer headsmen, killer bandits, killer kidnappers, just name it. And somebody also made reference to killing in the southeast, linking it to IPOB or non-government Eastern Security Network. All has been linked to.
I didn't hear that part. But the fact is that let me just quickly interrupt. Say this. I didn't hear the part of someone linking claims in the southeast. I had about criminality.
Somebody mentioned it.
I didn't hear that one. So the fact is true. Clear. We are talking about trial. We're talking about criminality. You see, trial is based on where there's offense comes. Now become is a freedom right. Right to self-determination is clearly provided for under Article 20 of African Charter of Man's Rights. In 9, domesticated into our law, part of our laws. It's important for me to say this on a closing note. And I believe I've said it in many forums, many media interviews. Let us all be honest ourselves. What is the root cause of the agitation in the southeast? Are you telling me the injustice being meted against them has been stopped? The answer is no. It's founded on injustice. Now, the government has ample time before now to engage this man. Let's listen to these people. What are your grievances? What are your challenges? What are your problems? Let's dialogue. Let's discuss this matter. But they have no regard for them, because I'm sorry to use this expression. Our people are regarded as third classes in this country, and they're being treated as such.
So my quality people, that brings us to the end of this update. Do well to like this video, share and subscribe if you haven't. Subscription is free. Please smash on that subscribe button that says subscribe and turn on the bell icon for more latest updates. See you when I see you. From me to you, from here I said bye.